Do you have constitutional questions? Get constitutional answers. We'll be answering your constitutional questions live, so get ready to call in now. Are you a prosecutor, law enforcement officer, or local government employee? Want to make sure you are executing the laws in a constitutional manner? Are you a city council member, township board member, or state legislator? Want to ensure the laws you pass are constitutional? Perhaps you're a citizen who wants to know the proper limits on government and the protections for your God-given liberties. Regardless of your role, call me, Constitutional Attorney Catherine Henry, with your constitutional questions during our live call-in show now at the phone number listed on the screen. And remember, together we can restore freedom.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We're going to see if things are going to work today. Hopefully they're working now. All right. Hello, this is Constitutional Attorney Catherine Henry. Welcome. This is Restore Freedom Weekly. And today is May 27th. And had a nice long holiday weekend with family, I hope, and remembering those who made the ultimate sacrifice for the freedoms in our country, the freedoms that we talk about in this very show. So hopefully you were able to do that. All right, so, okay, just checking out the comments. All right, guys, so I will go ahead and throw the number up that you can call in today. I have a feeling we're going to have some interesting calls, but we'll see. As a side note, Mike and I made it into the volleyball playoffs in our rec league. So we are in first place, and he and I have not played in 7 or 8 years. And so this is pretty exciting for us that we are getting to play volleyball. And it's a great segue to take a phone call. Hello. And this is one of our callers who has called before. I can't remember which one, but I assume that they will call back shortly here. In the meantime, if you... Hello, this is Catherine.
Hey, Miss Henry, this is John Q. Public in the chat. How are you today?
Good, how are you?
All right, so my trial started today on the CPO or CCW charge in Macomb County 16th Judicial Circuit Court today. So I just wanted to give everybody an update about what's going on. So if you recall, this is a situation where they don't honor LEOSA card, which is the Law Enforcement Officer Safety Act card. They don't allow that here in the state of Michigan, and they don't honor it. And so they're saying that you got to have a concealed pistols license in order to carry here in Michigan. And it doesn't matter if you served in the military or in law enforcement, they still are requiring it. So that started today. The judge suspended because they didn't have enough people for voir dire. And so now it's been suspended until June the 9th. But they're still trying to go forward with this here, and they're unrelenting on the prosecution.
What do you mean you didn't have enough people for the voir dire? You didn't have enough jurors show up?
Yeah, there was not enough jurors that showed up for the voir dire. I guess everybody's still on vacation.
Okay. Well, that's one way to maybe win if every time the jury pool decides they...
Yeah, they did. Yeah.
Okay.
Yeah, they didn't show up today, so that was kind of interesting. And what I was calling in to find out about, though, is my attorney is a court-appointed public defender, okay? So this is not from the public defender's office per se, because they just deal with misdemeanors. So it's because this one's a felony, it's a 5-year felony. They had to go outside and get a court-appointed counsel, and that's what they did. So, anyways,
wait. I have to pause you there. So,
okay, go ahead.
You're saying that in Michigan, there is a county where the public defender's office only handles misdemeanors, and if somebody's charged with a higher offense, then they have to seek an individual counsel to represent the person?
Right, because this here is a constitutional issue, and evidently they don't have a staff that's qualified there in Macomb to handle a constitutional claim.
See, that's crazy to me.
Since I'm arguing this on Second Amendment.
That's crazy to me because, so when I was still in Michigan, in fact, when I lived in Ionia County, I served as a public defender in Ionia and Montcalm counties. And it was basically we had this list of attorneys. There was no office of public defender. It was just this list of attorneys, and the judges would just go through, and whoever's next on the list, they'd grab that name for the next case, etc. And so, I think we still lived in Belding. So maybe 2018 or so, the state of Michigan was pushing the counties to create public defender offices to really, and I don't remember if the rule, it was like codified in the court rules or some other mechanism somewhere, but I feel like it was pretty official that counties were supposed to go through and really create these long-term offices. And typically speaking, then the public defender would be voted into that position. Just like in Michigan, you have the county prosecutor, the prosecuting attorney is what they're called. You vote for them. And so with the public defender's office, you vote then for the chief public defender, and then they hire in their own staff, just like with the prosecutor's office. And that's the way it should be. But even in a small little county such as Ionia County, in the middle of nowhere, Michigan, you have the chief public defender who is supposed to be able to handle any kind of public defender case, any kind of case that needs a public defender. And typically he's not even supposed to be the one that's handling the misdemeanors. He's supposed to have his underlings, right? His assistant public defenders handle those. And he and maybe one or two other staff, because it's a small county, would handle the felonies. So you're saying in Macomb County, which is more populated than Ionia County by far, that the office of the public defender only handles misdemeanors, and they have to seek outside counsel for not just constitutional issues, but you're saying for felony cases.
Yes.
And that blows my mind. But anyway, okay. That's
They have a very small office. If you're familiar with the 16th Judicial Circuit, that's in Macomb County, Mount Clemens. They actually are occupying, the Office of Public Defender is actually occupying the old Farmer Jack space that was right across the street from the courthouse.
Okay. Just
so anyways, yes, it is. It is extremely strange. But so what my question was is this court-appointed public defender has been, shall we say, very unorthodox in the way he presents himself and conducted his affairs as an attorney. Today, when the trial was supposed to start and he was supposed to submit the motions, number one, to dismiss on, number one, the plate issue was the number one issue, the veterans plate, disabled plate issue was supposed to be dismissed. That would stop the whole thing entirely. But then going on to the Second Amendment issue with open holster carry in your own vehicle, that was supposed to be tried to motion to squash and throw out, as well. He decides not to show up, and this is after confirming to make sure I'm going to be in court tomorrow, which I've been for every one of my court hearings. I'm on bond, so, I'm on the bond, and haven't done anything to violate bond, nothing at all. But then he decides not to show up today, and I get the riot act from the judge, and this I guess attorney from his office has a very low P number. It's like an 800,000 P number. So a relatively new attorney just acts like this is a big nothing. Well, no, it's not a big nothing for you, because they can incarcerate me right now because the judge is absolutely livid with his performance so far in this. He's delayed these motions for like 2 months now, and he was supposed to have these motions in And it's getting to the point where the prosecution is fed up with this too. They want to go directly to a trial. They don't want the judge to look at any of the motions. They don't want to hear any legal arguments. Basically, they want to head on a silver platter. How often does this happen like this, where you have public defenders that are court appointed? He acts like, you know what, this doesn't matter because I'm getting paid anyways, so it doesn't matter how long I prolong this out for. But, I mean, is this normal? And is there anything that I can do about this whatsoever? Because I see the judge is at her wit's end, but it seems like she's taking it out on me. And I have nothing to do with what the court-appointed public defender is doing.
Right.
As a matter of fact, he canceled 3 appointments with me already when I wanted to follow up and make sure he's doing the case right.
Okay, so let me just pause you there just so I can start answering some of those questions because I'm going to forget what they are otherwise. So first of all, what can you do? You need to document everything, document the motions that he said he would file that he has not filed. And if there's anything to back it up with, if there's notes in the Register of Actions, go get the most current Register of Actions, which, and I am sorry if you're outside of Michigan, listeners, but in Michigan specifically, there is a Register of Actions, which is essentially the docket, but sometimes there's minute entries in there where there's just notations made by court staff and things. So anyway, get the most current copy of your Register of Actions, and it's an ongoing criminal case. In theory, you should be able to get that for free, but they might charge you depending on how criminal they are. Anyway, do what you got to do to get that, and then look through and see if there's any kind of notation or reference to these motions that the attorney was supposed to file that they did not file, okay? Second of all, you want to get any kind of record keeping that you have of the appointments that the attorney has missed or moved on you, canceled on you for the two of you to meet. And then certainly today's hearing for not showing up, you need to have the notice to appear. And then if you said you got a call from the attorney yesterday to confirm that you were going to be there today, is that correct?
Yes, at about 8 o'clock in the evening. He actually wanted me to call him back about 8:30. Okay. I did so, and he just said, no. Okay.
Pause right there. So just, you have phone records at any rate, whether it's even just a screenshot that shows the caller ID or whatever, have all those pieces of proof to show that that attorney knew that there was a court hearing and failed to show. Have the, get the transcript from today. Now, it might take a little while, but start the process of ordering the transcript from today. And if there is a video, if this is a court that still has things done by Zoom or, they've put it on their YouTube channel or something like that, get a copy of that right away as well. You might be able to just download it from, their website or whatever if they have that streaming there. Otherwise, you might have to go through like Allegan County. They make it difficult, make you pay $20 per DVD to get a copy of the hearings. But anyway, do what you got to do to get that as well. So to show that this is having a drastic impact on you, that the judge is getting frustrated and you're worried that there's going to be literal consequences, physical, material consequences for you in your case because the attorney failed to show. But have all your ducks in a row to show all these problems, right? That the attorney didn't file certain motions or didn't do so on time, that they have neglected meeting with you and preparing in this trial, that they have neglected their duty to, I can't reach, anyway, to, appear for this, even though they just confirmed with you, sounds like 12 hours before you were supposed to be there kind of thing. Get all that together and put everything you can online somehow, whether it's just like in a Google Drive where you can have a link to that and make it shareable. But go to your attorney, go to the state, Michigan State Bar Attorney Grievance Commission. If you Google that, there'd be a way to file a grievance and then reference as succinctly but as complete as you need to the main points of what happened with this attorney and itemize, what evidence you have with it. So I have, phone records. I have, audio recording or video recording of this hearing. I have, the notice to appear. I have the Register of Actions, whatever kind of documents or things that you have. put a link in there so that they can reference those materials. If anything's short enough, include it with it, but sometimes it's easier just to have a link to various pieces of evidence. So anyway, what I would do also is I would file a motion pro se. So, on your own, I would file a motion for ineffective assistance of counsel and ask for new counsel and identify the exact same things that are going on and just say you are ready, willing, and able to proceed, but your counsel has been dropping the ball and even failing to go forward, and that you can't obviously control what the attorney is doing, and you had no choice about which attorney, and not that you're trying to control the process, because judges want to make sure that you're not just trying to be, beggars can't be choosers kind of thing, but that you make it clear you are taking this case very seriously, and your time and effort and the court's time, you are very aware of the impact that this has when the attorney is not doing their job. It's affecting the prosecutor. It's affecting, the judge. It's affecting you as the client. Kind of lay that out in both your attorney grievance commission complaint, but as well as a motion for new counsel, and lay it out as a Sixth Amendment, ineffective assistance of counsel, basically. And try to lay that foundation. It might get denied, but at least for appellate reasons, you are laying the record, you're putting it all on the record now. Okay. So, at any rate, that's what I would do as far as going forward. I don't know if I have anything else. And I will tell you this, that it's not, as far as how common it is, public defenders get a bad rap. But here, let me tell you this, and this is not going to be a surprise to you, that attorneys are crappy no matter what state, no matter what kind of law, and no matter whether they're getting paid by the client or getting paid by the system. There's just bad attorneys out there. I have been appalled to be, on opposing sides of attorneys that say it's a divorce case. And the attorney is just terrible, doesn't read the law, doesn't keep up with things. Maybe he's been in practice 30, 40 years, has no clue about the new cases or the changes in the child support formulation or guidelines, or, changes in different cases, case precedent that's been coming down, or the way the family law statutes have been happening, evidentiary issues, any of that. I've seen where attorneys just do literally less than the bare minimum. And it not only hurts their client, but it hurts my client in the process. It hurts the kids, etc. And so I don't think it's a unique problem to public defenders. And I will tell you, I was also in the public defender system in the state of Minnesota, which I can't speak to it now because it's been several years since I've been licensed in Minnesota. But back when I was a Minnesota licensed attorney and when I was an assistant public defender for the state of Minnesota, I literally was employed by the state of Minnesota, not even the county, by the state. We had a statewide public defender system, and it was phenomenal. And were all attorneys good in that role? Oh, absolutely not. But I could tell you that my predecessor was good, and then I took his spot when he went private full-time, because it was small enough area that I covered 2 or 3, 4 counties, that I handled all adult misdemeanors and all juvenile delinquencies in those counties. And that was considered only part-time work. So anyway, but the system itself was set up to help public defenders and to provide resources. And we're talking about almost 20 years ago. Wow, that makes me sound old, but we're talking about almost 20 years ago. And it was, again, it was just the system was set up different. But, at any rate, I have seen a lot of attorneys in the public defender roles. I can think of one that I went to law school with, totally diametrically opposed ideologically, mind you. His name is Evan, but super smart and one of the hardest working people I have ever encountered, also ex-military. I just don't remember what branch. But anyway, he is a phenomenal attorney in the public defender's office. I think he's in Ramsey County, which is St. Paul. But anyway, just the people that I can think of that I have known personally in the system have done a wonderful job. Does that mean that they don't,
error or, let things slide or whatever. No, I mean, I think there, like I said, there are bad attorneys in every scenario. I mean, even when you're doling out the money left and right to pay an attorney, you can end up having a really bad attorney who's very lazy, doesn't keep up on things, doesn't file the motions that they're supposed to, doesn't show up in court. That, unfortunately, is not all too uncommon. Now, over the weekend, I finally got to catching up on the Michigan State Bar journals. I think I was trying to go through 3 different ones. So I don't remember which one it was. It might have been the February 2025 version, but in the back of the State Bar Journal, they go through the attorney discipline records. So attorneys that have been found to need a final order of disciplinary action, whether it's being disbarred, whether it's having their license suspended, whether it's some sort of other corrective action. And I saw that a Kent County panel was convened, and I don't know how that part works. I think it's only a few panels throughout the state that convene to hold these hearings. But anyway, a Kent County panel recently found somebody essentially guilty of attorney misconduct, severe attorney misconduct. And the person was not only a public defender, it was the chief public defender for Muskegon County. The chief public defender for Muskegon County. And the records and the allegations, I couldn't even take it all in because it's, tiny little print, single space, whatever. It's kind of like reading the Bible, depending on what version you have. If you don't have the blind old person version, it gets a little overwhelming to read. But anyway, it was overwhelming the amount of rules of professional conduct that this attorney was found guilty of. After all his due process protections, they had hearings and different things, evidence was presented, etc. He had an attorney, or he had the option to, present his own evidence or make his own arguments or whatever. At any rate, it's not just a public defender, it was a chief public defender, the public defender for the entire county of Muskegon, which is just mind-blowing to me. It was refreshing, but mind-blowing that they were actually willing to publicly hold accountable someone in that kind of a position, because usually it's the good old boy network through and through, and attorneys don't want to admit when attorneys are doing wrong unless it's political in nature. And this didn't seem like it was political in nature at all. It was just a bad actor doing wrong and hurting people. So anyway, I want to give you that tidbit as a recent bit of factual support to give you hope that something can and potentially will be done. And that's why the more you can document what you are saying, be very clear. I have, think of it as like your standard 5-paragraph essay in school, like I'm trying to get my daughter to work on for her schooling lessons. But you have your intro paragraph and you're going to say, I had these, let's say 3 main issues. He's not timely filing motions. He's not, succeeding in look at what the Michigan rules of professional conduct are, and you'll be able to figure out what rules he's violating. But, kind of lay out what the rule, what the specific issue is, and very succinctly in that first paragraph, and then lay it out with factual support in the paragraphs below. And then in your conclusion, ask for, maybe just kind of reemphasize what it's been doing to you, and ask for them to do something because, other people in your position shouldn't have to go through this same thing as well. So, we're all presumed innocent until proven guilty in a court of law, and you're not given that fair shake. So anyway, that hopefully answers both sides of your question there. I know you had some more stuff that you were saying, but I wanted to at least be able to get out some of those answers before I forgot what we were, all those pieces that we were talking about. So did you have any other questions about it?
Well, you just mentioned about that, you remain innocent until proven guilty. I can tell you for a fact, now being the one going through the criminal justice system, that is not the case at all. Especially what I have been through here. It has been very eye-opening, being on the other side, and you are indeed guilty until you are proven innocent, or something is done to, mitigate that circumstance. I can tell you that is indeed not the case. The court does not treat you as an innocent person. Law enforcement doesn't treat you as an innocent person, and none of the court staff, nor society in general, especially with the media and the press the way they are, they do not treat you as an innocent person at all, and that just does not seem to be the case. I know that that's the way it's supposed to be, but in the reality, it is not that way, and there are negative consequences that happen to a person just by simply being accused or charged of something. What I did want to end with was one final question, and then I can hang up and listen for the answer. Based on the information that I have given the court-appointed public defender, we're not going to say case law, but judicial judgments that have been rendered by the Supreme Court and other courts within the Sixth Circuit here, which would include Michigan and other adjoining circuits. How compelled does the judge have to be to follow those judicial judgments in her rendering of decision on the motion in favor of the Second Amendment? Does she have to adhere to those? And if she does not adhere to those judicial judgments, is there any consequences for her, given what has happened to three justices lately for not adhering to rulings that have been put forward by the court?
Okay, so you're asking if the judge in your case is bound to follow the rulings of which court?
The Supreme Court and also the court within the judicial circuits in the appellate courts having to do with Second Amendment. So there's been recent rulings in the Third Circuit, Fourth Circuit, and Sixth Circuit.
You're talking about at the federal level?
Yes, at the federal level.
Okay, so generally speaking, yes, the lower court judges, even state court, lower court, trial level judges would be bound to follow case precedent from the higher courts, which would include the U.S. Supreme Court, only on matters of federal constitutionality. So if you're raising, for example, what is it, Article 1, Section 6, if I recall? I'm probably totally getting that wrong.
Article 1, Section 6 in the state constitution, but the
So if you're raising Article 1, Section 6 constitutional issues from the Michigan State Constitution, as well as Second Amendment issues from the U.S. Constitution, that one's actually, let me back up and say, after I started giving that answer, I realized it's not entirely accurate because last I checked on this issue, the Michigan Supreme Court has ruled that interpretation of Article 1, Section 6 follows the jurisprudence or case precedents of the federal cases regarding interpretation of the Second Amendment. I think Article 1, Section 6 of the Michigan State Constitution goes a little bit farther, and there should be even more specific protections. But at any rate, it's not going to steer you wrong if you can say the government overstepped on my rights based on this, based on the Second Amendment, and this court, the U.S. Supreme Court, has told you already how you have done that or how they have done that. You should be able to utilize U.S. Supreme Court precedent, but just the way that judges work, any amount of state Supreme Court precedent that you can cite, or even state, the Michigan State Court of Appeals cases that you can cite if they're published cases, because in Michigan, the Court of Appeals, most of the decisions are unpublished. But if you can cite to published decisions, meaning they are meant to be shared and have those decisions applicable to other cases as well, that's the whole point of having published versus unpublished decisions in Michigan anyway, then the judges are just, practically speaking, more likely to follow that than they are to, no judge wants to be, I'm not saying this is right or wrong, I'm just saying practically speaking, no judge wants to be the first one in a state court trial level, to be the first judge to all of a sudden utilize a United States Supreme Court precedent on a particular issue. They want to be able to look to courts that are more closely controlling what they do on a day-to-day basis. Does that make sense?
It does. I was just trying to follow whether or not she had to. She was compelled to follow those decisions, even if they're recent. Given Heller is 2008, and then we have the most recent one that was done, which was the Perez versus Suarez one that was done recently, which was in 2024 here, and then we just had Kipke versus Moore that was just done recently, which had to do with sensitive spaces. So
the problem is, I'm probably not the best one to ask that question to, because in my humble opinion, judges are not bound by anything other than what the Constitution actually says, right? And the thing is, the Second Amendment is pretty damn clear. And so we shouldn't have to have, it's unconstitutional to have concealed carry. So in Florida, it's illegal to open carry. In Michigan, it's illegal to concealed carry without specific permits and permissions and all these, extra rules and regulations. And I think all of that is nonsense. And I think all of that is unconstitutional. So to me, what is she bound by? My real answer is that she's bound by the Constitution. And if she's actually doing her job as a judge, she would declare, she would sua sponte, meaning on her own, dismiss the charges against you, because you can't be found guilty of this administrative nonsense where they're trying to take a right and turn it into a privilege that you can then be taxed and regulated and have your permissions denied and all the rest of those things. It is a basic right to be able to defend and protect yourself and others. So is she bound? She's bound by the Constitution. Practically speaking, the way that it works, like the way that you're taught in law school, yes, she would be bound to follow the U.S. Supreme Court precedent on these very issues. But I'll say that's academically speaking. Practically speaking, she's going to feel more bound to follow what the Michigan Court of Appeals and the Michigan Supreme Court have said. So if I were you, I would cite to as many of those as possible. And if there's new U.S. Supreme Court precedent out there, and don't get me wrong, I cite, in my state cases, I cite to the U.S. Supreme Court all the time because that's the supreme law of the land when it comes to these constitutional issues. The U.S. Supreme Court is the supreme law of the land, and the U.S. Hold on, I can't. All my words are not coming out right. The U.S. Constitution is the supreme law of the land, obviously, on constitutional issues as well as everything else. It's the basis for everything here. The U.S. Supreme Court and their decisions on that, the way our legal system is set up, is they're the supreme law of the interpretation land, right? For anything that comes down from that. So hopefully I finally got all my words right, because sometimes I don't say exactly what I mean when I'm talking about that. I blend two different ideas trying to get it out too fast. At any rate, so what I would do if you can't find a local case, a Court of Appeals or Michigan Supreme Court case that are talking specifically and citing these new U.S. Supreme Court cases, I would find the Michigan Court of Appeals and Michigan Supreme Court cases that are most close to the issues at hand, that say that matters of interpretation for these constitutional issues, that the Michigan Supreme Court has been directing judges to utilize and rely on the judgments made by the U.S. Supreme Court on these very issues. So at least cite to those as a practical matter. So anyway, hopefully that kind of helps you out there. She's also bound, she's bound by to enforce the law, but it's only to the extent that those laws are constitutional as well. So,
well, I think we all appreciate a future Justice Catherine Henry maybe on the bench, because it looks like you would be in favor of a lot of what we talk about here on your channel here. So I thank you again for answering my questions, and I appreciate the time. I'm sure you want to have other callers. Thank you.
Sounds great. Have a good day and good luck, and let us know how it goes.
All right, man. Bye-bye, Jenna.
Bye. All right, guys. Yeah, I'm trying to figure out what notes I want to make about that. But anyway, let's see. There we go. I almost had the right thing here. But let's go ahead and there we go. Even better yet. So I'm not even sure. It looks like you're missing letters in your username, NDER. But somebody asked, as a practicing lawyer, how can I tolerate the absolute nonsense that's repeated as gospel by the more ignorant or delusional members of my audience? I don't know exactly what you're talking about, and I don't always read the conversations that are going back and forth amongst people, so it's very hard, especially when I have a little tiny screen and it scrolls as it sees fit. If you have a specific question, by all means, share that. By the way, I just want to point out, Lori, you are, in the last, week or so, you have really messed me up because you have the exact same, you're using Mike's Facebook, what do you call that, image. His profile picture is that treason picture that you have now, and that's what he's used for the last, I have no idea, 4 years or something. And so it messes me up because I'm like, wait, Mike's contacting me or Mike's saying something, and then I see your name attached to it, and anyway. I get a chuckle out of that. So, okay. I'm just trying to see if you have any other questions. Yeah, so Lori at 12:24, if you want to scroll back through the chat, she says, if you have a question, please type it like this, and then the word question in all capital letters, and then you type in your question in normal capital letters at that point. And okay, shoot. It's trying to follow along and it scrolled on me again. I don't know why. So there is some chat back and forth. Oh boy. Okay, I don't see anything that says question. Just a lot of chat back and forth. If I have missed a question and you have posted a question in there, then please let me know. Oh, did I see one? Okay. Is there a difference in procedure in small claims court versus civil cases? So, John, that's asking that, you have to forgive me. I know that you've been in the chat and we've talked and things like that. I don't remember if you're from Michigan or not. So I will say, this is a generalization that is probably applicable to all the states. Louisiana is always its own, like, foreign country, basically. The way their court system works, the way their statutes work, everything. It's mind-blowing. And yes, I've been there, working on legal issues after Hurricane Katrina, trying to help clean up their legal issues as things were so devastating down there. But anyway, it's still mind-blowing and boggling, and I can't quite wrap my mind around all those procedures and processes down there. But to answer you from a Michigan perspective, that it can be generally applicable across the states. So the procedure in small claims generally follows a case in civil court. Now, you have certain things that are specific in Michigan to small claims. So for example, if you can't have attorneys in small claims court. If somebody wants an attorney, then they have to file that request, essentially let the court know, and it gets moved to district court, generally speaking. And so then you can have an attorney. If you don't like the outcome of a small claims case, it's considered binding arbitration is essentially what a small claims court case is in Michigan, because you have no right to appeal a small claims decision. I once filed small claims case myself for us as a family, not on behalf of other people. So that's how I was able to do that. And it was an insurance issue, and the judge, I've told you guys this story several times in different contexts, but the judge very smart man, very good. I truly believe he cares about the Constitution and constitutional issues, but nobody's perfect. And we walked out of there where the other side, it was an insurance issue where insurance denied coverage wrongly for something for our kids that had bonked heads on a trampoline and both ended up in the ER. At any rate, they were denying the coverage on that, even though we had specifically emergency room coverage. So the problem is the judge literally said to me, if I was a country, he said, Mrs. Henry, if you were a country bumpkin and not an experienced attorney, able to understand the legal issues involved here, I could rule in your favor on this. But you are an attorney, and whatever the rest of his reasoning was at that point. That's not how it works. The laws don't apply any differently to attorneys as they do to country bumpkins, so to speak. And contract law 101, if there's any ambiguity in a contract, you have to interpret that contract against the party who drafted it. So in favor of the other party who didn't write it. And it was an insurance contract. I sure as hell didn't write all the nonsense that was in there. It was the contract that was forced upon us as part of my husband's employment. And so even the other side, when we walked out and I was talking to my husband, and it was his employer. It was this weird thing where it was like they were self-funding the employee coverage. So it was a representative from his employer, as well as the third party, the people that were the third party company that was like writing out the checks and things like that and benefits, that they had like 3 or 4 different representatives from those various companies all there for the small claims case. And when we were standing outside, even the president, I think it was, from his company, when I said that was total BS because there's no way that we should lose based on contract interpretation when you guys are the ones that wrote the contract. That's contract law 101. And I'll never forget that the other side looked me straight in the eye and looked at my husband and said, "You're right. I'm really shocked that that's what happened here." So at any rate, we couldn't do anything about it because it was a done deal. It was a small claims case and you can't appeal. As far as if you're asking about procedure during the case, it's generally more relaxed standards. I don't believe the rules of evidence strictly apply in small claims cases like they do in civil cases. There's probably other things that would be applicable, but without knowing any specifics that you're asking, that's the best I could do to answer that question. And shoot, okay, it just scrolled on me again. I hate this software does that like that. Okay, so I think I've answered all those questions. Okay, so I see there's a lot of conversation between Lori and Wanda. I think it's been about the court system. I haven't had a chance to really fully read all that, especially the way that it scrolls funny and jumps around on me. But if there's a question in there, if there's a specific point or question in there, by all means, let me know. And I would, love to jump in and answer, but feel free to continue the dialogue amongst yourselves. That's fine as well. So, gosh, there's a lot of things going on. There's just so much going on in our country right now. And I don't know about you, but I am, even I, as someone who was not afraid to stand up and take on the entire state government of Michigan, the governor, the attorney general, the secretary of state, the Republican Republican controlled legislature in 2020, fight them all the way to the Supreme Court, challenge the orders. I was the only attorney that stood up and said from the beginning, these orders, these executive orders shutting down our state, forcing masks, all this garbage and nonsense is it's been unconstitutional from day one. Unconstitutional from day one. It's been illegal since whatever the date would have been, April 30th of 2020, because that's when the Republican legislature finally decided to not extend for a second time her stupid executive orders, although the House voted to codify the large percentage of her executive orders into law. Thankfully, the governor vetoed that law. I mean, it's fantastic that she chose to veto that. But anyway, it was, I'm not someone who looks in the face of adversity and goes, oh my gosh, I'm just so defeated. However, okay, I do see a question. I'm just going to finish this thought, and then it looks like Wanda has a question. So see, that helps me because I haven't even been able to read the whole question, but I just saw question in capital letters. So, all right, so I'm going to come back to that in a second. But what I wanted to say is, even I have felt like it's overwhelming to keep up on, first of all, just keep up on what's going on. I cannot physically keep up on everything that's happening at my local level, at the municipal level, at the county level, at the state level, at the national level. There's too many things happening. There's things happening in the legislative branch. There's things happening in the executive branch. There's things happening in the judicial branch. And that's at all three levels of government. And it's overwhelming and it's insane. So, for example, you might think you're super well informed just by knowing bill numbers in your state legislature, or U.S. Congress, right? Bill numbers, HB 470, for example, in the state of Florida, the weather modification bill. And it started off as a good bill, and we were there supporting it, and we were there in person. And if it weren't for the fact that we were there in person and saw how quickly they adopted an amendment that gutted the whole bill and then voted almost unanimously to pass the bill on to the next committee, and then there on out it's being voted on in that new amended form in the gutted sense, and didn't do anything that the original bill drafter had intended it to do. If we weren't there, if we wouldn't have seen that, we wouldn't have known exactly what happened, and to know that that bill was no longer a good bill. And so that's just one bill, but it happens all the time. And I'm really disheartened that, it's a full 8-hour trip to go there and back to the state capitol for me now, whereas it used to be, 2.5 hours round trip for me to get to Lansing in Michigan. And certainly when I lived in Minnesota for a while, I actually lived in the capital city in St. Paul, made things a lot easier to be able to contact state legislators. But at any rate, it gets overwhelming just to stay in the know. But even when you read, and I'm, I don't know, maybe 4 years ago. Okay, hold on. Hello, this is Catherine. Who am I speaking with?
My dog Rex in the chat.
What's that?
My dog Rex in the chat.
Oh, okay. So are you from Michigan?
I used to be. I got a son and daughter up there.
Okay, where do you live now?
Fort Myers.
Oh, okay. Well, I guess I should have noticed. It's a 407 area code. So, all right. So what can I help you with today?
I just wanted to comment this Memorial Day, all these people who were murdered or died or went off to murder people in the name of liberty. We're celebrating them, but never do we celebrate any judge or a prosecutor or city council member, because they're all liars and thieves. Everything we've discussed here, this guy had a gun, but he has every right to have a gun, yet he's being beaten to death by the Nazis and the Chinese that we fought. But no, he's being beaten to death by these judges and attorneys and police officers and city councils. And like you said, The legislation that is changed in an amendment that they never tell you about. Oh, it just boggles my mind how we got to prove that I am not a slave and you are not my master. The idea that even a police officer pulls you over on the side of the road when you're not engaged in commerce and says, give me your papers. The question is, are you my master? No. Am I your slave? No. So why are you bothering me? Well, the law says, but you just said you're not my master. But yet you're acting like my master, and if I don't do what you tell me to do, you get to beat me to death because you're wearing a costume or a disguise while prominently displaying a deadly weapon. And if I don't obey you, my master, somehow you get immunity and you're allowed to beat me up. And I just can't comprehend how this is even possible at all.
So there's a lot there in your comment. So is there a specific point or question that I could address today on that?
I guess it would be standing. Who has standing to make any claim whatsoever? I'm under the impression that the injured party is the only one that has standing. If I break your window playing baseball in your house, I am the perpetrator, and you have standing to make a claim against me if I refuse to right my wrong. As long as I'm willing to try to correct the wrong I've committed against you, there is no claim. But if I refuse, then you have to bring in other people, or you're going to shoot me with a gun, which you have. It would be excessive in this instance of a broken window. But the idea of these courts is to keep us from shooting each other over silly things or even major things. So who has standing to make a claim, say, that I was speeding if I didn't hurt anybody? And it's all settled case law that if there is no injury or harm or victim, there is no claim.
Well,
yet these
it's not a settled case law point. I know a lot of you have said that, but there's nothing settled about that at all, because that's one disadvantage of relying too heavily on cases, is because in most circumstances, whatever point that you make that you can find case precedent for, you're going to find case precedent that says quite the opposite, and it could be from the exact same court. They could vary it based on one tiny, seemingly insignificant consideration in the case. It could be just different justices, a few years later, a few years down the road, came to a different conclusion because the majority changed. It could be a variety of different things happening. But on virtually all the major issues that we have, there's nothing that's deemed, solid or settled case precedent in that regard. As far as, the standing, you're talking about standing in a criminal case is essentially what you're talking about. Right?
It would be standing in any case. Standing is standing. Either you've been wronged or you haven't been wronged. And if you haven't been wronged, you have no standing to make a claim. It could be criminal or otherwise. Criminal is go ahead.
See, that's where you're starting off with an assumption that is not, your assumption at the beginning is based on something that's not actually settled case precedent. So the whole concept of civil law, where it's a party versus another party, that's where standing really comes into play. Because you can't have someone, if we have the neighbor issue, right? If you broke my window and I wanted to personally do something about it, I wanted to sue you about that, I would have standing to do that. But would my next door neighbor have the ability to sue you for breaking my window? No, because there's no standing there. But it's a different, but it's a totally different ball game when we're talking the criminal law context. And there is. But
I did say the injured party has the standing.
But
your neighbor has no claim whatsoever.
But you're missing what I'm saying. I'm saying you are correct when it comes to civil cases. Criminal law has a totally different context. Now, don't get me wrong. I've served as a public defender. I've been a private public attorney. That sounds wrong. You know what I mean? A private criminal defense attorney. But my premise is, first of all, more freedom, less government. We have far too many laws on the books that are unconstitutional, things that criminalize behaviors in a malum in se kind of way instead of malum prohibitum. Or it's malum prohibitum kind of way, where it's only bad, it's only wrong simply because someone in the government has said it's bad. It's not inherently wrong. But I would say, for example, murder. If you murder, it should not be, let's say you murdered my husband. It should not fall on my shoulders to utilize standing to take you to court and solve that situation. You are a danger to society in general when you are a murderer. The government, that's one of the rare instances, and I will say it's rare, but it is one of the rare instances where criminal law actually needs to be utilized in that respect. People that are human trafficking, that's another, instance where you're not going to be able to have the people who would have standing under your theory, the child victims of human trafficking, they have no ability to bring some sort of lawsuit against their traffickers. Many of them are literally held in captivity until there is some sort of, investigation and arrest and then trial. And then those people are found guilty and then they're locked up and, so.
Right. Well, in that instance, with the child is the victim, then the McKinsey friend, so to speak, the next friend would be the state would step in.
No, that's a thing. The McKinsey thing that you're talking about is for people. It's a totally different context. It's not at all to be utilized in that scenario.
Well,
and there is.
I'm saying it's sort of the idea of that, where the state would step in on behalf of the victim because the victim has no capacity whatsoever.
But that's what that's the proper role of state prosecutors right now. They just go far beyond what their proper role is. But what I'm saying is that the whole premise of having criminal prosecutions in our country, I agree that there is a purpose and a premise for having the government do criminal prosecutions. What I don't agree with is when they are criminalizing things that are not inherently dangerous or harming other people, like you're talking about. When there's no victim, in most scenarios, I would agree that there is no crime. The problem is there are times where we don't necessarily easily identify a specific victim, but there are people being harmed. So I would say, for example, you said speeding, right? Let's go with that for a minute. My neighborhood, my little residential neighborhood is, I want to say it's 25 miles an hour. It's a standard speed limit, okay? And if somebody came through and they were going 60 miles an hour on my street, I don't think I should utilize vigilante justice. Now, you better believe if I'm outside and I see it, or even if I'm near a window that's open, I'm going to be screaming and hollering my head off and threatening them with bodily injury if they don't slow down, because they're going to hurt the children playing in the neighborhood, or pets or whatever. Like, that's not okay. That is a real and present danger to the scenario. If you're speeding through a school zone and there's school in session, right? There's kids that are literally needing to cross the street and, whatever. That's the kind of thing, so if we're talking about just having, you're not alone in that there's a lot of people, especially in this chat, that think all of those, I'll use air quotes here, administrative rules and regulations are, they're not enforceable. And, it's this whole concept of, you're not engaging in commerce and that kind of thing. And I would say I call BS on that, because there is a purpose. There is definitely a purpose in having rules about if there's a school bus. Sorry, my throat is getting hoarse. But if there is a school bus and it puts its stop arm out, there is a real safety issue with having cars go, oh, well, I don't have to abide by any traffic laws because I'm not engaging in commerce and I'm just going to zip right around this bus, no harm, no foul. Yes, you might not have injured a child in that exact scenario because maybe somebody, jumped in and grabbed them out of the way, or maybe, just the timing was serendipitous and you didn't run a child over. But that's not the point. Do you see what I'm saying? Like, there is a time and a place for those kind of, I'll say again, in air quotes, the administrative regulations that maybe seemingly there is no victim in that scenario, but it's a very real and present danger. Now, should there be criminal prosecutions for the vast majority of these administrative regulations, of these things that are just put on the books? In Michigan, that you concealed carry without a permit. In Florida, that you open carry without a permit. Or you can't even open carry with a permit. What am I saying? You can't even open carry down here unless you're hunting or fishing or whatever the stupid other exceptions are. The whole point is, no, there shouldn't be criminal prosecutions for that. Or if you're within 1,000 feet of a school zone. No, I think that's stupid. And it's not just me saying it's stupid. There's no real and present danger to someone by that. So I don't know if that's making sense to you, but what I'm saying is there is a time and place for a small fraction, but yet nonetheless some of those people, like prosecutors, to do the job that they're doing for some of the offenses that they prosecute for. Does that make sense? I mean, do you at least see what I'm saying? Even if you don't
It
agree
does
with
make sense, say with the school bus issue, that there is a high potential of harm or injury, and I would say that would be like disturbing the peace. You're disturbing the peace of the other people that are utilizing these services, and you are creating a very potential harm, and that would be disturbing the peace, and they can deal with it. But like you say, they're going so overboard with it, and the police are seemingly permitted to beat you to death nearly.
Well, I totally agree with you that there shouldn't be qualified immunity. I kind of heard that without you saying those words. I heard that was one of the complaints that you were making. And I think virtually anybody, I think, that's ever watched any of my videos, regardless of what party affiliation they have, would agree that qualified immunity is bullshit. There should never be such thing. If somebody violates your constitutionally protected rights, they should have no immunity for that. It's if we don't have accountability within our own government, then how do we enforce the law? If those who are supposed to be enforcing the law are not even held to a standard of having to follow the law, then they shouldn't be there. You can't have your cake and eat it too. So I would totally agree with you on that. Sorry.
and that's the difficulty I have, is that it's impossible, unless the government brings charges, unless a prosecuting attorney brings charges, the criminals walk free, and they will not prosecute the government employee, no matter which government employee it is. It could be a mayor spending ridiculous amounts of money on their own personal thing, but it takes the people 10 years to even get them into a courtroom. And
hold on a second. You make a good point. I just want to jump on that point. Okay, so you mentioned if a government employee is the one that's causing, they're violating somebody's rights. So they've committed a crime. They have violated somebody's constitutionally protected rights. And we'll make it easy. We'll say they intentionally did that, regardless of what right it was. Let's say it was a First Amendment right, and they denied that right. Okay, so excuse me. What I think, and that's a clear example of why I would say that prosecutors have a job to do. And this is one of those very real examples of where they should be doing something. Most of the time they do not, because we don't see government officials charged with crimes, which is stupid. But this is one of those examples of where the prosecutors, whether it be a federal prosecutor or whether it be a state level or local level prosecutor, needs to do their due diligence and bring these cases. And it shouldn't be a burden on, let's say it was you, and it was your rights, your First Amendment rights, that were violated. It shouldn't be on you just because you have the so-called standing, right, to pursue some sort of civil case against that individual in government. It shouldn't be up to you to bring any kind of criminal charges. It should be a fact that if that government official has violated your constitutionally protected rights, and let's say they openly admit that they did that, but they're like, yeah, but it's no big deal, and, you know, whatever. No. The government should be doing its job at policing itself, and they should be bringing those individuals to justice through the criminal justice system. And it should be a part of a system, not just a fill-in, not just like you're talking about a McKinsey friend or things like that. It should be, that is one of the main goals that a prosecutor should be working on, is those kinds of clear offenses that are completely unacceptable. It is unacceptable for any government official to violate the constitutionally protected rights of American citizens. End of story. You know what I mean?
Well, exactly. It's like the first caller you had has a public defender that is not doing his job. So the accused is waiting for a fair and impartial hearing. Now he has a whole nother case to pursue because his accusers won't even stand up for what do you call it?
A fair process.
Exculpatory evidence. They won't even,
well,
even the prosecutor won't say.
It wouldn't be exculpatory evidence, but one of the prosecutor's jobs in Michigan, and actually to the caller, I forget, I think your name was John, but I forget. To that particular caller, I just want to say, if you're still watching, check out my briefs from my Allegan cases that I had in the Michigan Court of Appeals, where I talk about the procedural due process protections. Actually, it might have even been in the substantive due process protections. But anyway, where I talk about, I have like several different things about the prosecutor's duty to ensure that there is a fair and just case being handled. It is, before a defense attorney ever hits the case, it is the prosecutor's job in the state of Michigan, according to the Michigan court rules and the Michigan rules of professional responsibility for attorneys. It is the prosecutor's job to ensure that the constitutional rights of a defendant are protected in the case. So there are a lot of things that I cite to that point in those briefs. And so take a look at those, take a look at, the table of contents, try to find where that is in there, but that's a ton of stuff you could grab and copy and paste. Sorry to you as the caller now from Florida, but you reminded me of that.
It's okay.
So
it's okay, but he doesn't have any machinery to compel the prosecutor to perform his duties. The prosecutor should be stepping up and saying, hey, I can't go forward because the appointed public defender is failing to perform his duties.
Yeah.
The prosecutor would never say that to the judge, but he should. And that's what I'm saying. And now the victim, has no recourse, no opportunity to compel mandamus the prosecutor to perform his duties.
So, yes and no, but I would say it's more basic than that. In that case, the prosecutor's number one job is to make sure that the constitutionally protected rights of the defendant are adhered to. And that means not even bringing those particular charges to begin with, because it's one of those administrative, it's bad just because the government has said it's bad and there is no harm to anyone. So anyway. And it looks like Lori just put the link in the chat to the page where you can find those briefs. So anyway, so I think you said a bunch of other things, and I apologize. I was trying to address them all as you were saying them, so I didn't forget. But I think I've forgotten the other topics you might have been bringing up. So.
That's okay. I could go on and on, which is I don't want to take over everything, and I appreciate your time. It's just that we people, and you've experienced this in your driveway, have no way to stop these madmen because the government will not enforce your rights.
Yeah.
It's just frustrating. Thank you, Catherine.
Yes. Have a great day. All right, so we had a question. There was a lot going on in the chat since. So let's see, I'm not seeing any other questions, but I am trying to find the one that I said I was going to. Dang it. Wanda, you asked a question. Oh, I found it. Okay. What in the articles? Not sure what articles you're talking about, so we're going to have a problem with that. But what in the articles states the government has authority or jurisdiction over people who didn't consent or contract to be governed? Don't know what articles you're talking about, but what I will say is that our constitutional republic, it's we, the people, not every single individual person. When our country was formed, when everything was started, it was people essentially coming together from the most local divisions of our population and getting together more and more representatives. Okay, the caller just hung up, so feel free to call back if you want. But anyway, where people were representing those in their communities and going to the next highest level, if you want to think of it that way, and having people continually represent them. And so it was those, when it boils down to it, it's I point because it's got it on the wall, but we have the signers. We have the signers to the Declaration of Independence, but we have the signers to the original Constitution, where, yes, it wasn't every single person that even was in our country at that point, because that's just not feasible. But it's the people that signed it that were representing all of those people. And so that's how you get into these social contracts. So it's not, let me see. Hello?
Hi.
This is Catherine. How can I help you?
Yeah, Catherine, constitutional attorney. How are you?
I'm doing great. Who am I speaking with?
Charles.
Okay, and where are you calling from?
Oh, I'm down south.
Down south? As
Yep.
in, like, Alabama, Florida, Georgia, somewhere?
Arkansas.
Arkansas. Okay.
Is that considered south where you're from?
Well, I'm in Florida, so technically I'm farther south, but I'm a Michigander by heart, so yeah, you're from the south.
Well, I'm watching you live, and I guess there's some kind of delay. I figured I'd be able to hear myself on the YouTube.
Oh, there might be. I think there is a little bit of a delay. I don't know exactly how long it is, but what can I help you with today? What question did you have in mind?
Is this live? I guess I'm a little one.
Yes, we're live.
Oh, okay. Oh, wow. Well, it's Memorial Day, so I thought I usually don't do stuff like this, but I thought I'd call and see what you thought about a couple things. And I really appreciate what you do. I've been watching you since you've been doing this, among several other people on the internet, when it has to do with constitutional rights. So I just thought I'd call.
Okay. Did you have any point in particular that you thought was interesting or had a question about today?
Yeah, man, I can go on all day about it, but
Well, just give me
I was
one.
Really, sure. I was really curious what you thought about the new case, constitutional case, 9-0, I believe, something like that, Barnes and Felix. Are you up to date on that?
In what court?
Supreme Court.
The U.S. Supreme Court?
Yeah, yes, ma'am. You gotcha. May 15th, I think, just last week or so.
I have not seen, well, it depends on what you're talking about. I guess I don't necessarily know cases by names, but what's the case about?
Excessive force. Some kid was shot and was stopped and shot within seconds. It was, I was reading about it. I just was curious to see if you knew about that. And it was a 9-0 unanimous decision about a kid that got shot, which has been happening for a long time now. So I just thought I'd call and see what you thought about that. It was totally unanimous, and how it could affect the totality of circumstances, that leads up to an arrest or whatever. What you thought about that versus qualified immunity?
Well, I can't speak to that case because nothing is coming to mind. I generally consider myself someone who tries to stay on top of the newest cases. I'm on a listserv that I get, emailed when there's new cases that come out from both the Michigan Supreme Court and Court of Appeals as well as the U.S. Supreme Court. And so I do try to stay on top when new cases are coming out, but that fact pattern is not coming to mind. So I apologize for that, so I can't speak to that specifically, but generally speaking, as far as, and I can't glean from how you've described it what way the court ruled on that, but there should never be qualified immunity. I don't think there should be qualified immunity for any government officials. As far as if there's individuals that are, I think that the initial purpose of providing qualified immunity is when you have individuals that, we're all humans, right? So people are going to make mistakes. Every government worker is going to make mistakes in their lives because they are human. And so you have to have the ability to allow people to make human mistakes and still be able to do their jobs. However, I don't think people should be having lifelong careers in government. So that's, something we should consider. We shouldn't be worried about somebody maintaining a lifelong career in any kind of government position. And it should never be a consideration about, especially if somebody has been physically harmed, but certainly if they've had any kind of other trauma or, monetary setback or anything like that, because a government official has done wrong, I would be okay with the government official perhaps keeping their job and being able to still do those functions if they made reparations to the individual that they harmed. So, for example, the lowest of the totem pole, let's say a cop pulls somebody over and they give somebody a ticket for something, but it turns out that they had no lawful right to pull somebody over, and that whatever they wrote the ticket for was nonsense. There was no bearing with that, but the person had to go through...
Right, like this case I was speaking about was about a $6 unpaid, some kind of ticket.
Okay.
I don't know, some kind of ticket.
So let's say the jurisdiction does not, let's say the defendant in that case would acknowledge, yeah, I had a $6 unpaid parking ticket, but the state statutes don't allow for me to get pulled over and arrested for that because that's, stupid.
Yeah, he got shot. Yeah, the kid got shot and his mother
regardless
filed the
of being,
lawsuit.
regardless of being shot, it sounds like the bigger question is, was there even a right to make the stop and pull somebody over?
Of course not. Right. That's
and
the whole.
So, right. So depending on the state statutes, I would assume that I'm
I think
assuming,
it was the Fifth Circuit, I believe. Fifth Circuit. There you go.
Okay, so I don't know what the state statutes
They're all
were on.
relatively the same, really, but I mean.
Well, they're not. They're not at all. They're not at all the same. They're not at all the same.
Well, I mean, like officer safety.
But hold on. I'm trying to answer you here, and you keep interjecting.
Yeah.
Me. But the
Oh, sorry.
if you have,
I'm not. Sorry, I apologize.
if you have a jurisdiction though where what I would expect is that there is no legal justification for arresting someone based on a $6 unpaid parking ticket, as would not be, that would be the case in the Michigan Motor Vehicle Code, for example. You couldn't do that. There's no justification that way. There's no authority to do that. Then for somebody, we're not talking about the case you're talking about where there's actually been somebody physically harmed. We're talking about where somebody just had to go to court and they had to take time off of work and they had to fight it out in court and maybe get a public defender. Maybe they just fought it on their own, but they had to do different things and they had to say paid $20 to park, downtown Grand Rapids, to go to the courthouse to fight the ticket, whatever the case may be. Any of those out-of-pocket expenses, I would think that in this scenario, even in such a benign situation, that cop would have to reimburse the person who they caused that harm to. If they had no legal standing, no legal authority to take that action, they should have to make that person whole. But it's one of those benign things that if they, cause somebody to have to fight an improper traffic ticket, and that's the worst of it, that's all that had happened, and it wasn't done, with malicious intent to abuse process or, have malicious prosecution. If it was done with the best of intentions, but you just had somebody who was ignorant and didn't do a good job that day, I don't think they should lose their job. They should just have to make that person whole, if that makes sense. It's one of those
Sure,
things
yeah.
where people make mistakes and we have to be able to account for that human element, but also recognizing that the rights of government officials should never outweigh the constitutionally protected rights of citizens. So, anyway.
Well, nice answer. Yeah, kind of like harmless error. What do you think about harmless error, Anna? You know, you're familiar with that, right?
Well, so for those who are not, generally speaking, harmless error is the concept that when you appeal a case, depending on this, generally speaking, if you appeal, let's say it was a criminal case and you file an appeal, but you did not raise a specific issue, the issue you want to appeal about, you did not raise that at the trial court level, you did not preserve the issue for appeal, then what they have to look at is a standard that typically they will use, the harmless error standard. And so if it was a plain error or harmless error or whatever, there's different standards to look at with regard to what kind of error it was. But, and there's some degree of common sense to having these different rules and processes, but I don't agree with most of it, but I can see where they came from, right? At any rate, with harmless error, what they're saying is if that particular thing, and that's within the context of a trial, right? So let's say the judge allowed a certain witness to do testimony, or did not allow a certain witness to provide testimony, or didn't allow a certain piece of evidence in, or they did allow a certain piece of evidence in. If that particular piece of evidence or witness testimony or whatever it was, if that would not have actually changed the course of or the outcome of the whole case, if there's not a real potential that it would have changed the outcome of the case, then appeals courts will say that was a harmless error. Yes, it was an error. Yes, the judge should not have allowed that piece of evidence in, but let's say it was a bench trial. Let's say the defendant, that just makes it the easiest, that it was a bench trial. The person elected to have a judge instead of a jury deciding their fate. And the judge made it perfectly clear that they didn't care about, any of that particular kind of evidence. They were looking at this issue over here and this other evidence and these other facts that determined this person was guilty of the offense charged. So there is some sense to having that harmless error standard applied, that you don't get relief for that. I mean, I don't think somebody should be able to skate out of, a murder conviction, for example, based on a harmless error type of situation. The unfortunate part is that far too often the error is not necessarily harmless, and it does actually impact the fairness, the overall fairness of the underlying trial. But not only that, there's still, even though you shouldn't be able to get out of, that particular conviction, perhaps, depending on the situation, there still should be something done so that those kind of errors do not continue to happen. So that a judge does not, in that case, with harmless error, it's about what a judge does typically. And so a judge would not see that as licensed to continue making those kinds of choices, because they're like, well, I'm never going to be held accountable to that. My decisions are not going to be overturned. If anything, it would be considered a harmless error and it would be no big deal and the case would still be upheld. So
Wow.
I think that there should be some sort of accountability, but it just depends on the scenario. If it truly is harmless error, then the person should not be getting scot-free off of a conviction, say, for murder. You know what I mean?
Yeah, I do. My point is, wow. This seems to be happening throughout the United States, especially in the last 20 years, this harmless error. Judges they overlook a lot of things these officers do, or even employees of the state, like whoever, and it seems to be a problem, and it keeps the courts really jammed up, and people, having to appeal slam dunk cases or cases they should win, right? I guess that's where I was going with it, and I was kind of tying it into qualified immunity. It kind of seems like the same thing for the court. That's just the way I look at it. What do you think?
I'm sorry, I don't understand the question. Can you kind of word it differently, maybe, or?
Yeah, this harmless error. All these judges. I've been watching you Direct D people for years, right? And I hear people are going pro se. They're filing these, the meritable cases, when they've been wronged, right? And a lot of times these people are getting screwed over by the court, I guess you could say, because of like harmless error or the judge overlooking some evidence. I don't know. I guess that's where I was going with. And it kind of seems to me like it's like the court's qualified immunity, this harmless error, like in a case.
Oh, I see. You're saying it's kind of analogous to that.
Yeah, like an analogy or something, right?
Yeah, I mean,
it
essentially...
seems really out of control, our court system.
It's a little bit like that concept, but it's a little bit different because if you have a criminal conviction and you're filing an appeal and then the issue they're talking about is whether it was a harmless error, the most that would happen in that case is that your case, your conviction gets overturned, or you have it gets sent down for a new trial or whatever the case may be there. But in the case of qualified immunity, that's actually impacting your ability to directly go after that individual for doing wrong or violating your rights. Whereas the other part is just trying to rectify the outcome of what has been brought to you, or, charges brought to you. So it's not even to the point of you trying to hold any particular government. No particular government official is held accountable in,
sure seems that way.
I mean, the whole, even if the court determined it was not harmless error, right? It was harmful error made by a judge.
Better way to put it.
There's nothing that comes out of that will directly impact the the judge that made those decisions, because it's not a civil case. The jurisdiction in that case is over the person who's the named defendant.
Well, I bring this up because I've got 3 lawsuits. I think I sent them to you from Arkansas. Do you remember me? I have 1 on appeal and 2 against 2 other officers here.
Maybe. I get thousands of emails, so...
Oh, I bet you do. You responded. It's been a while.
Okay.
But anyway, it was, got mistreated, and I'm suing the government, on my own.
That's good. And people should.
Yeah.
More people should sue the government officials for doing wrong and violating their rights. Absolutely.
Yeah, definitely. Yeah. I've been doing it on my own, and I had to file an appeal based off all my evidence was most, I'd say 99 point whatever, with the state's own evidence about what they did wrong with their own documents, right? But yet here I am filing an appeal because of some harmless or willful error because of the judge, right? She overlooked lots of stuff.
Yeah.
Lots of state records. It was the prosecutor. I mean, total wow. So that's my whole point about the harmless error. It's like, how can the judge overlook that, and why am I filing an appeal?
Yeah.
If that makes sense.
Yeah. No, it does. Well, thank you very much for calling in, and you brought up several different issues there.
Well, I've got a bunch of them. I've learned a lot over the years. You really can't trust any of these people nowadays, especially police officers. It's just sickening. So I don't know. I guess I'm feeling Memorial today, so I thought I'd call you. So I really appreciate you letting me talk, but I could go on forever. But,
well, make sure to call back in at our next show or bring up some other topics. So.
Yeah, maybe I will. Yeah, I really appreciate it, and happy Memorial Day.
Yes, thanks. Have a great day.
Yeah, take care. You too. Bye.
Okay. Oh, I'm sorry, Angry Vet. You were asking for a reference to those cases. I didn't know those were the cases you mentioned in the chat that you wanted to read, but apologize for that. I could have asked him so you could get a case number. Again, you're not putting in all capital letters the word question and then normal uppercase, lowercase letters for what the question is. That's going to alert me to the fact you're talking to me. So anyway, just something to keep in mind. That's what makes it easy. Let's see here. I don't see any further questions that have come to me. I did scroll up and down. If I missed your question, I apologize, but it's already been an hour and a half. Time flies when you're having fun talking about how the government does wrong. But I would encourage you guys. I was saying before, the angry vet is pointing out that Memorial Day is not a happy day. It's remembering people who have died protecting our freedoms. And certainly we want to, I guess there could be happiness in the fact that we can appreciate the ultimate sacrifice paid by those who were fighting to defend our constitutionally protected freedoms. So with that being said, I did change the screen here to put the links up for you guys. Anytime that you are fighting the government in any way, anytime you are having to defend yourself because a case has been brought against you, or you have just had enough and you are bringing a case against somebody else, whether it's a court case, whether you are trying to, take some action steps at your within your local city government or county government, whether you're advocating for legislation to be changed or enacted at your state government level, whether you're talking with federal government employees, whatever the case is, when you are involved with or engaging with government officials, it can be overwhelming, and it could be hard to figure out how to structure or divide your topics, define what the issues are. Anytime that you feel like you just need a little bit of a boost, a little bit of help to see what some of these kinds of arguments might look like, please feel free to check out the website, restorefreedomkh.com. You could go to the resources tab, or for those of you who are listening and just want a direct URL, that would be restorefreedomkh.com/resources. Please utilize whatever resources I have on there, especially the Allegan County case, the Ormond Beach case. There's some very recent stuff on that case, but there's a lot of different constitutional arguments in those documents. And if anything can be useful to you guys in your own fight for freedom, that's why I put it out there for free for you guys to utilize, copy, use the formatting, whatever might help you there. And if you're looking for the specifics of the recent case that I've talked about many times in the course of the last couple of years that we still have pending in the Florida Court of Appeals, then go to restorefreedomkh.com/OB case, as in Ormond Beach case, OBCASE. If you do want to support the continued work that I do, whether it's answering questions twice a month during these shows, whether it's drafting legal documents and briefs, whether it's putting out the short videos or traveling to the state legislature to encourage our legislators to make good constitutional changes in our statutes, anything else like that. If you want to continue to support my work, whether it's a $5 one-time donation or a $500 monthly donation, whatever you guys might see as appropriate to encourage and support the work that I do, you can go to restorefreedomkh.com/donate. We could use all of the help that we can get there. Even if you just want to share the word, spread the word about what it is that we do, that people can call in for this show, that they can sign up for the newsletter, that they can just see different news and tidbits and videos about various cases and new statutes being enacted, different things like that. You can go to restorefreedomkh.com/support, and you'll be able to see the other side of that. There's two choices there. And the other side, I think, is shop, where you can get any number of our Restore Freedom items, whether it's the Restore Freedom pop sockets, great little, oops, I can't even figure out where my camera is there. Great pop sockets. They last longer than the phones do. We have often transferred a pop socket from one phone to another. So that means more than 2 years these pop sockets can last. And we have the window decals. There's all kinds of stuff on there. I don't even remember what everything, car magnets, things like that. And Lori has posted some of those links in the chat there. So please, yes, whoever the last caller was, I think you said your name was Charles from Arkansas. If you can, please connect with the Angry Vet in the chat here, the guy with the handle, the Angry Vet, because he is interested in the cases that you were talking about and how you had said you had sent me cases and I had responded, and I just couldn't have the connection of exactly what cases you were talking about at the time. But anyway, the Angry Vet is interested in reading your cases that you're pursuing against government officials. So please connect with him in the chat here or otherwise. So at any rate, I would encourage you to take, to click on those links that, okay, I see Lori did anyway, I'm seeing some other stuff in caps. The Angry Vet, dude, you're kind of messing me up when I look and I see that you're putting stuff in all caps. It kind of catches my eye, but not quite, they're not quite questions for me. You're just talking to other people. Anyway, I'm not seeing any other questions. So if I have missed your questions today, then I'm sorry that I've done that, but I've done my best to, of course, answer the questions from the callers that have called in, as well as those of you who are in the chat. I've scrolled through and tried to catch all those. But with that being said, please join us the second Tuesday of the month. That would be, I'm just double checking here that I'm not losing my mind. Yep, okay. So the second Tuesday of the month is going to be June 10th. Join us then at noon Eastern Standard Time for our next show. Eventually, either Lori or I will get up on our website the short videos of some of the speeches that Emma and I both made a little over a month ago now. We're both working on it, but there's a lot of things in the works here. So Angry Vet, I understand there's a lot of people that even send me emails that are in all capital letters, and they tell me it's because they can't see very well, and when they put it in capital letters they can see. I'm just letting you know that it's hard for others to read it. So but at any rate, okay, I don't know if this was a question for me, but it's the last one that I see, and so I will quick try to address it. Somebody is saying, somebody who has called in before, do you have a problem with the license of your right to work? So I will address that very easily by saying, I've already answered this before. I think that I can't think of a good reason why somebody should have to be licensed. So I view licensing, whether it's getting a barber's license so you can cut hair, or a license to practice law, or a license to just simply operate a business, having a general business license or contractor's license or whatever. I view those licenses as basically akin to having a Better Business Bureau accreditation. So I don't believe in the Better Business Bureau, right? I don't believe in if a business has really great ratings with the Better Business Bureau, it doesn't really mean anything to me. And they tried to bully me when I first opened my law practice. They wanted me to pay $500 whatever every year or something like that so I could have this accreditation with them and go through this whole process. And I'm like, are you kidding me? Either I'm a good business or I'm not, but no, I'm not going to pay you to tell people I'm a good business. But at any rate, it's one of those scenarios where I think with licensing or think of it this way, a lot of state bar jurisdictions, you have the general bar to be able to practice, and you could practice any kind of specialty. You could say I'm an estate planning lawyer, or I'm a bankruptcy lawyer. That's a bad example. There is a different federal court that you have to be licensed in to do bankruptcy law. But you could say I'm a divorce lawyer, or I'm, a contract attorney. So you could practice in any one of those areas. But if Michigan, through the Institute of Continuing Legal Education, allows you to obtain certain certifications where you are a specialist, you have gone to tons of training and checked all these other boxes to show that you are an attorney with a lot of knowledge and experience in a certain area of law. So that is a marketing tool. That's essentially, so if you think about it, you might, if you're getting a divorce, you might want not only an attorney who advertises that they do divorce work, but you would want an attorney that is certified as a family practice expert, right? Who's done checked all these different boxes and been super trained and has all this experience in being able to do family law cases. And so although Michigan doesn't require an attorney to go through all that extra stuff just to be able to say you're a Michigan divorce attorney, right? I've worked on hundreds of divorce cases in Michigan without having those specific extra qualifications, but I didn't care to have that extra marketing tool. That's what I think licensing in general should be, whether it's, like I said, a state bar license, or whether it's, the license to cut hair or do nails, or even a contractor's license. And then it becomes the whole system has to change, though, in a way that it makes it perfectly clear that there's a buyer beware scenario. So, then there needs to be some big push to advocating to people. You need to check on that. You need to make sure when you hire someone that you, okay, I hope everything's okay. Something just changed on my screen at the top there, so I'm not sure if I disconnected for a period of time or not. But anyway, you need to be able to, as the buyer, right? Somebody who's hiring a contractor, for example, you want to make sure that they have insurance, that they have whatever all their credentials, that they know what they're doing. You're going to find out about that. It shouldn't be a mandatory thing that somebody has to go through and do all those things. But as the buyer, as the customer, you're going to want to ask those questions. Okay, well, do you have insurance? Okay, let me get that insurance information. Okay, did you take, any kind of licensing tests? Have you, what kinds of experience? Do you have letters of recommendation or references, that kind of thing? So it's a matter of marketing. That's what it should be. They should be voluntary types of programs where you are able to, essentially bolster your intake in your business to be able to say, yep, I have all these certifications or licenses or whatever. It shouldn't be something that can be utilized to get in between you and doing that particular business. So anyway, that would be my answer to that. So okay, and there's been continuing chat. Oh, shoot. So I'm just going to quick see if there is, wow, it keeps jumping. You guys have chatted the whole time that I was saying that answer. Okay. Okay, so it looks like there was a question about a contract. Where did that go? Oh, shoot. Okay, do I have a contract with any bar association? Wanda wants to know because she cannot find an example of one. No, there's no contract. This is the last question because we've been on here now an hour and 45 minutes, but no, I don't. As an attorney, I'm admitted to practice currently in 5 or 6 jurisdictions, and I used to also be licensed to practice in Minnesota, although at some point I realized I'm not going to be going back, so I resigned from that state bar. But I don't have a contract. I've never had a contract. What I have had to do is take an oath. But that oath is not between me and a court or me and a bar association. That oath is an oath to uphold, support, and defend, uphold, support, defend, whatever the wording is for that particular oath, the U.S. Constitution. And if it's a state court, then it would be the U.S. Constitution and the state Constitution. So when I got sworn in to practice law as a Michigan attorney, for example, I had to take an oath to uphold the U.S. Constitution and the state Constitution of the state of Michigan. There is no oath to allegiance to any kind of bar association or court system or anything like that. So just something to keep in mind. And in fact, I in 2020, I think it was, maybe early 2021, I had done a video specifically addressing this and the oath of and allegiances of bar attorneys, and specifically going over what several states have as the actual oath and what you're swearing to and what your oath is and to whom it benefits and things like that. So take a look at that video. Like I said, it's just if you go to my own website and you could search bar attorneys, you should be able to see that video from 2020 or 2021. And I've done a couple other videos and things since then talking about that. But you'll be able to see, and I actually put in at least a couple of those videos where we talked about this topic. I've actually put in there the actual language. If you're looking for documents, I've put in there the actual language of what attorneys sign on to for their their oath. What is the actual language of the oath that they are taking that day? So, all right. Oh, looks like Lori might have found it. Bar attorneys, common law, civil law, and all the rumors. And then she has a link to that. So I think that must be the one that I was talking about. If not, I've done a couple of them, at least 2, if not 3 or 4 videos about that. So, all right. With that being said, it's been a great, lively chat today. You guys have had lots of questions and lots of things going back and forth. Dude, I answered your question. I don't know who you're calling sheep, but I answered your question. So if you don't like the truth, then this is not the channel for you. If you don't like facts, this is also not the channel for you. But that is the truth. So, all right. Thanks, everyone. I appreciate all of you joining us today, and join us again in 2 weeks on June 10th for our next live episode of Restore Freedom Weekly. And I will hopefully be able to get a little bit more in the habit of getting some of those shorter videos and legal update posts going to let you guys continually know about the things that are changing in our courts, and so we can help each other stay informed on those important issues. All right. Thanks so much, guys. Have a great day.
Our work to restore freedom would not be possible without support from people just like you. From the various software and hardware needed to the legal research materials, every dollar you can donate helps. Make sure to like and share this video too. And remember to follow and subscribe and click that notification button. Together, we can restore freedom.